Hello, my name is Chan Xuan Yao and I'll be doing the introduction. Arbitration is a form of dispute resolution in which the parties agree to submit their dispute to a neutral third party, an arbitrator or an arbitral tribunal, for determination, and to be bound by the resulting decision, the arbitral award. As a result of the UNICITRAL, the United Nations Commissions of International Trade Law, there is a considerable degree of harmonization of the national laws that provide the domestic framework within which arbitration takes place. In England and Wales, the framework is provided by the Arbitration Act 1996. In Malaysia, the main legislation applicable to both domestic and international arbitration is the Arbitration Act 2005, as amended by the Arbitration Amendment No. 2, Act 2008 Arbitration Act. These two acts have the objective of enhancing the features of party autonomy in arbitration and have up-to-date provisions that keep up with key development in arbitration practice.
Hello, my name is Shaila and Jackson and I will be covering the relevant provisions and case law concerning challenging the award in the UK, which are Section 67 and 68 of the Arbitration Act 1996. These are mandatory provisions which cannot be contracted out of by the parties. A party may lose the right to object under Section 73, which include time limits that a party to arbitral proceedings must abide by unless he did not know and could not with reasonable diligence have discovered the grounds for the objection. Besides that, the right to apply is subject to the restrictions in Section 70 sub 2, which includes the requirement to first exhaust A. any available arbitral process of appeal or review, and B. any available recourse under Section 57, correction of award or additional award. Besides that, Section 70 sub 3 states that any application must be brought within 28 days of the date of the award, or if there has been any arbitral process of appeal or review, of the date when the applicant was notified of the result of that process.
Hello, my name is Jackson and I will be talking about Section 67 of the Arbitration Act 1996. Section 67 can be used to challenge an award made by an arbitral tribunal as to its own substantive jurisdiction, or to seek an order that an award made on the merits of the claim itself is of no effect, whether in whole or in part. It differs from challenges to substantive jurisdiction brought under Section 31, which is at the outset of the proceedings, Section 32 as a preliminary point, or Section 72, which is rights of a person who is alleged to be a party or takes no part in the proceedings, in that Section 67 operates after an award has been made. A party to arbitral proceedings refers to a person who takes part or continues to take part in the arbitration, in contrast to a person alleged to be a party but who takes no part under Section 72, subsection 1. A party to arbitration may make an application to the court to challenge an award once they have given notice to the other parties and to the tribunal. However, a party must have exhausted any process of appeal or review under the arbitration rules, the arbitration agreement, or any recourse available under Section 57, which is the correction of an award or additional award. Substantive jurisdiction is defined in Section 82, referring to Section 30, as A. whether there is a valid arbitration agreement, B. whether the tribunal is properly constituted, and C. what matters have been submitted to arbitration in accordance with the arbitration agreement. We will be focusing on the following areas. First, exhausting any available arbitral process. In the case of A Limited and B Limited, the Commercial Court considered whether the appeal process in an arbitration under the International Cotton Association rules had been exhausted. The claimants had sought to appeal the award to the ICA's Second-Tier Tribunal, the Technical Appeal Committee (TAC), but have failed to deposit the requisite sums with the ICA as required by the ICA rules, resulting in the ICA dismissing the appeal. The ICA refused the claimant's retrospective application for an extension of time to pay. The claimants then applied to the court for an order that the award to be set aside under Section 67 and or Section 68. The questions before the court were: 1. Was there an available arbitral process of appeal or review? And 2. If so, had the claimants exhausted the process so as to comply with Section 70, subsection 2? Mr. Justice Smith found that an appeal to a second-tier tribunal, such as the TAC, did constitute an available arbitral process of appeal or review, and the claimants had exhausted that process when their application for an extension of time for payment was refused. He noted that the important connotation of the word exhaust is that the process must be used up completely, and what matters is that the process is fully spent, and not how it becomes spent. Accordingly, despite the DAC appeal process being precluded as a result of the claimant's failure to pay the amount due, the salient point was that the appeal process had been used up, not how it has been used up. The process had been exhausted within the meaning of Section 70, Subsection 2. Second, extent of tribunal's jurisdiction. In the case of Interprods Limited, the Commercial Court dismissed challenges to the award brought under Section 67 and 68. The arbitral tribunal had made an award finding that the claimant's representative had told the defendant that the claimant needed the defendant to pay commission so that the claimant could use the commission to pay bribes, and the defendant was consequently entitled to terminate its agreement with the claimant and was not obliged to pay the outstanding commissions. Focusing on the Section 67 challenge, Interprods argued that the arbitration agreement should not be construed as extending to cover allegations of criminal conduct. Justice Thier disagreed and found that the parties, as rational businessmen, were likely to have intended that any dispute arising out of the relationship into which they had entered was to be decided by the same tribunal, unless the wording of the clause made it clear that certain questions were to be excluded from the tribunal's jurisdiction. He noted that illegality in the performance of contractual obligations is often alleged to be a reason why a contract cannot be enforced, and that it would seriously restrict the ambit of arbitration clauses if allegations of criminal conduct were sufficient to deprive the arbitral tribunal of jurisdiction to determine the contractual rights and obligations in the light of the criminal conduct. Justice Thier dismissed the Section 67 challenge. An arbitration clause should be construed widely as covering all disputes arising out of the particular relationships or agreement, including those where allegations of illegality are raised, unless the clause contains specific wording to expressly exclude certain questions from the jurisdiction of the arbitral tribunal. Thirdly, jurisdiction and cause. In the case of Sun United Maritime, following the rendering of their award on the substantive dispute, the party solicitors tried to reach agreement on cause. A dispute arose as to whether an oral agreement on cause had been reached. The defendants referred the question of cause back to the arbitrators. However, the claimant then sought an order that the arbitration had no jurisdiction to deal with cause, on the basis that an agreement on cause had already been reached and the tribunal was therefore functus officio. The claimant contended that the application fell within Section 67 because the issue as to whether the tribunal had jurisdiction to decide the cause of the action was a dispute about whether matters have been submitted to arbitration in accordance with the arbitration agreement under Section 30, Subsection 1c. Mr. Justice Hambian agreed with the defendant that the application did not fall within the scope of Section 67 because the question before the court was not one of whether the tribunal lacked substantive jurisdiction as defined in the Arbitration Act 1996, but there is a dispute as to whether a claim referred to arbitration has settled. They will generally fall within the reference to the arbitral tribunal because the alleged fact of settlement will be a defense to the continuing claim, and a defense like any other that the tribunal will need to determine. The same follows where the only outstanding claim is one for cause. He therefore found that the issue between the parties were instead whether matters which have been so submitted have been resolved by agreement. Castelli clarifies that any ancillary dispute arising out of related settlement discussions or negotiations on cause should be considered as falling within the ambit of the arbitral tribunal's general jurisdictions over the claims submitted to it. The remedies under Section 67, Subsection 3 for a successful challenge of an award as to the arbitral tribunal's substantive jurisdiction include having the court confirm the award, vary the award, or set aside the award in whole or in part. The latest decisions on application challenging jurisdiction shows that Section 67 remains a tricky, although not impossible, gateway to navigate. Decisions turn on the specific facts of each case, and the courts remain inclined to uphold the finality of the arbitration award. When considering a challenge on the basis of substantive jurisdiction, potential applicants should bear in mind that the tribunal can continue the proceedings while the application is pending under Section 67, Subsection 2, which can cause further unnecessary costs to be run out. A successful Section 67 challenge can often result in a full rehearing, not merely a review of the tribunal's decision, and can be very costly and result in further delay. Thus, the court isn't looking into the merits of the decision, but to decide whether or not the tribunal reached a correct decision, as in the case of Davaco. Parties would therefore be well advised to view Section 67 as a last resort, and consider challenging substantive jurisdiction earlier if possible under Section 31 or Section 32, or alternatively to abstain from taking part in the arbitration and seek to challenge jurisdiction under Section 72. Thank you.
I will now be talking about Section 68 of the Arbitration Act 1996. Now we look at challenges to an award on the ground of serious irregularity under Section 68. Historically, successful challenges under Section 68 have been rare. To quote the report of the Departmental Advisory Committee which led to the Arbitration Act in 1996, Section 68 is really designed as a long stop only available in extreme cases where the tribunal has gone so wrong in its conduct of the arbitration that justice calls for it to be corrected. Recent case law demonstrates that this principle still very much holds true in practice. Section 68 allows a party to arbitral proceedings to apply to court challenging an award on the grounds of serious irregularity affecting the tribunal, proceedings, or award. Serious irregularity means an irregularity of one or more of the types listed in Section 68 sub 2, which the court considers has caused or will cause substantial injustice to the applicant. An applicant therefore needs to demonstrate first that a serious irregularity has occurred, second that the irregularity falls within one of the categories set out in Section 68 sub 2, and third that the irregularity has or will result in substantial injustice. Section 68 provides an exhaustive list of irregularities. An applicant must prove one or more of the following kinds of irregularity. There is no single test for deciding whether an irregularity has caused or will cause substantial injustice. It is very fact-specific. As a rule of thumb, the court will need to be satisfied that but for the irregularity, the applicant would have dealt with the matter differently or the outcome would have been materially different. This is as per the Chantiers case. The need to show substantial injustice reflects the dual principle of party autonomy and finality of the award upon which the Arbitration Act is based. Having chosen arbitration, the parties cannot validly complain of substantial injustice unless what has happened simply cannot on any view be defended as an acceptable consequence of their choice. Serious irregularity must be likely to affect the award made. If the arbitration tribunal would have arrived at the same result regardless of the serious irregularity, the court will not see any justification in interfering with the award. In Shatari's case, it was held that the new evidence that was not allowed in would not have stood a realistic chance of reversing the verdict. Thus, there could be no substantial injustice. Now we will talk about the following areas. First, focus on due process, not correctness of decision. One of the more popular, and in the court's eye, overused category of serious irregularity is failure by the tribunal to comply with Section 33. That is the general duty of the tribunal, under Section 68 sub 2 sub 8. In Law Society's case, the claimant argued that the tribunal had acted in breach of its duty under Section 33 sub 1 sub 8 to act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of his opponents by allegedly overlooking and mischaracterizing certain pieces of evidence. Mr. Justice Fox was unimpressed with the claimant's application, which in reality amounted to an attempt to challenge the tribunal's findings of fact. He reiterated that the focus of the inquiry under Section 68 is due process, not the correctness of the tribunal's decision, and concluded that there was no question of absence of due process in this case. Justice Fox stressed that it is entirely inappropriate to use Section 68 as a mechanism for challenging the tribunal's finding of fact. Quoting from his recent judgment in the case of Primera, otherwise every disappointed party could say it had been treated unfairly by pointing out some piece of evidence in its favor which was not referred to in the reasons or not given the weight it feels it should have been. This is precisely the situation in which the court should not intervene. Matters of fact and evaluation of the evidence are for the arbitrators. This decision shows the court upholding the finality of arbitration awards. Section 68 is not to be used as a backdoor route to appeals of fact. The second area we will cover is no opportunity versus failure to take the opportunity. That said, here is an example of a partially successful Section 68 challenge involving Section 33 sub 1 sub A and therefore Section 68 sub 2 sub A. In Brockton's case, the defendant, in a post-hearing memorial, claimed that a subsection of the underlying contract was an unenforceable penalty. The claimant reserved its position on these new arguments but did not object to them. The tribunal allowed the defendant's new submissions, but its award referred to the whole of the particular section of the contract as being a penalty rather than just the subsection. Mr. Justice Field rejected the claimant's first argument, finding that it had an opportunity to object to the defendant's new arguments. By reserving its position, the claimant had failed to take the opportunity, and the tribunal was entitled to assume that the claimant had decided not to make submissions on the new argument. This meant that on that occasion, there was no breach of Section 33. On the other hand, by referring to the whole section rather than just a subsection, the tribunal had decided a further new submission introduced by the defendant, that the second subsection was also a penalty. The claimant had not had notice of the new submission and therefore had not been given an opportunity to address it. That amounted to a breach of Section 33, and that irregularity caused substantial injustice to the claimant. The application succeeded on this second point and the award was remitted back to the tribunal for reconsideration. Justice Phil observed that there is an important distinction between a party given no opportunity to address a point and a party failing to recognize or take the opportunity that exists. The claimant also argued that the tribunal's failure to refer to the evidence of one of the witnesses was a breach of its Section 33 duty. This argument did not find favor with the court, which concluded that it will only be in the most exceptional cases, if ever, that a failure to refer to a particular part of the evidence will constitute serious irregularity within Section 68. The next area we'll look at is robust but fair case management. In the Interports case, the Commercial Court dismissed challenges brought under both Section 67 and Section 68. The claimant identified 3 serious irregularities in the arbitrator's conduct of the arbitration, which it claimed were in breach of Section 33 and Section 68 sub 2, sub 8. However, here the court supported the tribunal's using of robust but fair case management methods in order to progress the arbitration where a party is being uncooperative. Disgruntled parties to an arbitration need to be very aware of the challenges they face in seeking to overturn an arbitral award on the ground of serious irregularity. The focus of any such challenge must be on the process and procedure used rather than the tribunal's findings of fact. The parties must also have taken every opportunity available to them to put their case to a tribunal. In the words of Justice Field in Brockton, the threshold for the test of a serious irregularity giving rise to a substantial injustice is set deliberately high because the purpose of the Arbitration Act was to reduce drastically the extent of intervention by the courts in the arbitral process. If an applicant successfully proves that there is a serious irregularity, the court may, by way of Section 68 sub 3, remit the award to the tribunal for reconsideration, set it aside, or declare it to be of no effect in whole or part.
Now I'll be talking about challenging an award in Malaysia. The relevant provisions governing challenge of the award under the Malaysia's Arbitration Act 2005 are Sections 37 and 39. An arbitral award is final and binding against the parties to an arbitration agreement, and those parties cannot appeal the award under the Act. However, where the seat of the arbitration is in Malaysia, the parties may apply to have the award set aside by the High Court. It appears that such right to set aside the award cannot be excluded by the parties. Previously, Section 42 of the Act, which is now repealed, allowed for a party to challenge an award on a question of law. In relation to this, prior to the repeal of Section 42, there was some confusion as to when the court should exercise its discretion to set aside an award on a question of law. This is shown in the case of Government of Malaysia and Perwira Bintang Holding Sendirian Berhad 2005. Awards may be challenged in the High Court proceedings brought to set aside wholly or partially the award. Under Section 37, subsection 4, an application for setting aside may not be made after the expiry of 90 days from the date on which the party making the application had received the award, or if a request had been made under Section 35, from the date on which the request had been disposed of by the arbitral tribunal. Whereby, in UK, under the Arbitration Act 1996, Section 70, subsection 3 states that any application must be brought within 28 days of the date of the award. Moving on, the grounds for setting aside such an award are set out in Section 37 of the Act. It states that the award may be set aside by the High Court only if the party making the application can prove that 1. A party to the arbitration agreement was under any incapacity. 2. The arbitration agreement is not valid under the law in which the parties have subjected to it, or failing any indication thereon under the laws of Malaysia. 3. The party making the application was not given proper notice of the appointment of the arbitrator or of the arbitral proceeding, or was otherwise unable to present the party's case. 4. The award deals with a dispute not contemplated by or not falling within the terms of the submission of the arbitration. 5. The award contains decisions on matters beyond the scope of the submission to the arbitration. Or 6. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties. Unless such agreement was in conflict with a provision of this Act from which the parties cannot derogate, or failing such agreement was not in accordance with this Act, or the award is contrary to public policy of Malaysia, or there was a fraud or breach of rules of natural justice, and such application do not form an automatic stay of enforcement of the award as it must be made by application and etc. Section 36, subsection 1, sub A, Part 5 of the Arbitration Act 2005 is similar to Section 67 of the UK's Arbitration Act 1996, as they both talk about challenging an award made by arbitral tribunal as to its own substantive jurisdiction. Challenging proceedings do not stay enforcement proceedings. Often, enforcement proceedings will be heard together. However, the courts have been reluctant to apply Section 37, subsection 1, Part A, Part 5, as shown in various cases such as Yusa Hasama, SPNB, Sendirian Berhad and Abi Construction, in another case of Sigur Rose, Sendirian Berhad and Maser Mulia, Sendirian Berhad, etc. Under Section 37, subsection 2, Part B, it states that an award is in conflict with the public policy of Malaysia where a breach of rules of natural justice occurred. This provision is similar in Section 68 of the UK's Arbitration Act 1996, as they both talk about the breach of natural justice. According to the case of Government of Lao People's Democratic Republic and Thai Lao Lignite Co. Limited, it stated that for a breach of rules of natural justice to apply, it must be shown that the most basic notion of morality and justice is offended. In addition, the general consensus of judicial and expert opinion is that public policy under the Act encompasses a narrow scope. According to the view of Ahmad Kamal JC, he stated in the case of MRCB, Engineering Sendirian Berhad and Lee Hon Min and others, that it should only operate in instances where the upholding of an arbitral award would shock the conscience or is clearly injurious to the public good or wholly offensive to the ordinary, reasonable, and fully informed members of the public. Under Section 39, it provides for the grounds for refusing recognition or enforcement of the award. An award may be refused at the request of the parties whom it invokes, where the parties provide the High Court proof that a party to the agreement was under any incapacity, etc. In Alami Vegetable Oil Products Sendirian Berhad and Hafiz Iqbal Oil and Ghee Industries Limited, the appellant's appeal was dismissed as Section 39 did not apply. The parties have to satisfy the grounds laid down under Section 39 in order for it to apply.
Hello, my name is Jazrin Harith and today I'll be explaining on the Malaysian law. In Malaysia, under the Arbitration Act of 2005, there is no right of appeal of an arbitration award. The only recourse available against an arbitral award is to apply under Section 37 to have the award set aside under the listed grounds. An arbitral award is largely immune from interference by the court. To promote arbitration as an alternative form of dispute resolution, restricting court intervention, as such, decided cases such as Ajwa for Food Industry Corporation, Egypt and Pacific Interlinks Sendirian Berhad and another, appeal indicate the courts should be refrained from intervening unless patent injustice exists. In order to reflect the finality of the awards, previous Section 42 and 43 Arbitration Act have been repealed by the Arbitration Amendment No. 2 as of 2018 due to the concurrent jurisdiction that emerged under Section 37A. The Asian International Arbitration Center, or AIAC, summary of amendments indicates that the only recourse available to set aside awards is Section 37. Questions of law may be pursued under Section 41 of the Act during arbitral proceedings, and the supervisory jurisdiction of the courts is reinforced by the ability to provide interim measures of relief. Extremely restrictive approach to setting aside an award can be discussed via case laws. In the High Court case of Sime Darby Property Berhad against Garden-based Sendirian Berhad, the court says that the rules of natural justice, any breach of natural justice, not in the manner of a technical or inconsequential breach, will be sufficient for the court to intervene under Section 37, 1b, subsection 2, read with Section 37, subsection 2b, applications to set aside. in the case of Interline Resources Sdn Bhd and ExxonMobil Exploration, Section 37 was not to be abused by applicants, and the threshold for judicial intervention is high at first. Intervention is limited to what is prescribed in the statute. Second, in order to uphold and respect party autonomy, the courts can only intervene in limited circumstances as defined in the statute, focusing on the fair process and on the right of the parties to the arbitration to a decision that is within the true ambit of their consent to have their dispute arbitrated, and plainly do not extend to the realm of vindicating the merits of correctness of the decisions of the arbitral tribunal. Courts cannot entertain setting aside applications which are in truth a manifestation of a desire of the regretful losing party in arbitration to be given another opportunity to argue the merits of its case. Time limits. A 90-day time limit is provided for under Section 37, subsection 4, which must be strictly adhered to. The courts in Cherm City Development Sdn Bhd and Kerajaan Negeri Selangor Darul Ehsan held that the court does not have an inherent jurisdiction to set aside an award even if an application is made out of time. But look at the case of Dato' Dr. Muhammad Rizwan bin Muhammad Saleh and another, and Syarikat Air Terengganu Sdn Bhd, where that this court has the discretion to extend time for the application to set aside an award, as the word used in Section 37, subsection 4 is may and not shall. The word may in Section 37, subsection 4 of the Act is to cater for circumstances where the ground of setting aside an award only becomes more apparent later upon the discovery of some breaches of the rules of natural justice. One of the notable amendments introduced by the Amendment Act is a repeal of Sections 42 and 43 in their entirety because of the emergence of concurrent court jurisdiction to set aside an award under Section 37 and Section 42. The existence and the exercise of such concurrent jurisdiction could have resulted in, first, unsolicited attacks on the finality of the award, second, endorsement of potential procedural abuse, and thus was contrary to the government's policy to promote Malaysia on a safe seat. The repeal of Section 42 of the Act has two important implications. First, parties will no longer be able to bring questions of law before the High Court after an award has been awarded. Rather, if the parties or the arbitration tribunal require clarification on a question of law, they will have recourse to the High Court during arbitral proceedings pursuant to Section 41 of the Act. Second, Section 37 of this Act is now the only recourse parties may have in seeking to set aside an award. This is the provision which has been used by Malaysian courts to set aside arbitral awards. Although Section 37 does not empower an arbitral tribunal to vary an award, the grounds for setting aside an award under the Act now align with Article 34 of the Model Law and the New York Convention. One should note that the repeal of Section 42 and 43 did not result in ousting the supervisory powers, but as a progressive step towards reinforcement of the principle of minimum court intervention, finality of the arbitral awards, and party autonomy enshrined in the Act. What is more important, the representative or judiciary noted that they only interpret the law and are supportive of the amendments. Once a policy decision on Section 42 is taken, the Amendment Act comes as such decision. Section 43 is also repealed as a consequence of Section 42. Thank you.
Appeals can be brought under the United Kingdom Arbitration Act of 1996 regarding questions of law arising out of an award. Unlike Malaysia, the United Kingdom, along with other developed jurisdictions, allows such appeals. On first instance, this may appear to contradict basic fundamental principles of party autonomy, confidentiality, and finality of awards, as indicated by Justice Saville. However, the Departmental Advisory Committee reporting on the 1996 Act contends that the appeal procedure under Section 69 was only ever meant to provide a very narrow avenue of appeal. Section 69 of the Arbitration Act operates extremely restrictively, providing to be not so much different to Malaysia in removing the section in its entirety. What amounts to a question of law as opposed to a question of fact often provides a very murky distinction. The case law relating to this concept defines questions of law to be those arising out of interpretations of legal principles, the construction of terms, and considering factors that were not meant to be considered, and vice versa. Unlike Section 67 and 68 of the United Kingdom Arbitration Act and Section 37 of the Malaysian Arbitration Act, parties are free to exclude the operation of Section 69 of the UK Arbitration Act expressly or through dispensing with reasons for the decision. Before having access to this section as well, parties must also exhaust all arbitral remedies first. For an appeal under Section 69 of the UK Arbitration Act, the consent of parties is required, or the parties can apply to the court for leave where the Section 69(3) factors are considered and satisfied. Whilst this suggests that parties may avoid leave requirements by merely consenting to an appeal, the court in Enterprise Insurance Company v U-Drive Solutions held that party agreement does not preclude the court from examining whether the requirements under Section 69(3) of the UK Arbitration Act are satisfied and determining whether it has scope of jurisdiction in the relevant case. According to Richard Lau, most of the requirements under Section 69(3) of the UK Arbitration Act are justified and unproblematic, except for the test on public importance, which is too stringent and a new test should be formulated. Nevertheless, the requirements under Section 69(3) provide an extremely high threshold to be satisfied. This is evident by the English Commercial Court report of 2018 that indicated that permission of appeal was granted in just 30 cases over the last 4 years. Of these 30 cases, only 5 of the appeals were successful. The limit of a right to appeal under Section 69 of the UK Arbitration Act has raised some serious concerns that the common law development is being impeded by this section and that the courts are unable to exercise their supervisory jurisdiction. As mentioned previously, Malaysia has remedied this by providing for avenues of interim measures to be awarded, as well as allowing for clarifications on points of law during the actual arbitration process itself. These sections are similarly provided for in the UK Arbitration Act, remedying any such arguments that the courts aren't exercising their supervisory jurisdiction. As such, Lord Thomas has explained that greater reliance should be had on Section 45 of the UK Arbitration Act, which allows for parties to apply during the arbitration process itself to clarify points of law. Section 45 itself has not been used frequently in arbitration processes, as there are only 3 reported cases of it ever being used. By using Section 45, consistency is ensured and clarifications of points of law are provided for at the time when it's most needed. This is successfully employed in Malaysia and under the unitrial model law, limiting the need for appeals under Section 69 of the UK Arbitration Act and bringing it in line with the Malaysian Arbitration Act. Both the Malaysian and the United Kingdom Arbitration Act provide for a specific time limit for bringing an appeal under their relevant sections, that being 90 days in Malaysia and 28 days in the United Kingdom. Unlike Malaysia, the United Kingdom does actually not specify whether this starts from the date that any clarification is sought under Section 57(3) of the United Kingdom Arbitration Act. The English Commercial Court has actually ruled on this matter this year and has said that only where correction is material to the appeal being sought will the time start running from the date of correction. This is evidently a lot more limited than Section 37(4) of the Malaysian Act. Both acts are silent regarding whether an extension of time may be sought when applying for an appeal. However, both courts in both jurisdictions have actually interpreted the matter in a very similar way. In the United Kingdom, for example, an extension of time may be granted where the interest of justice requires it. In Malaysia, it is permitted where the circumstances of setting aside an award are apparent after the time limit has actually lapsed. Nevertheless, the difference in the time limits reminds us that both of the legislations interpret the law differently, despite both aiming to provide efficiency in dispute resolution. The remedies available under the United Kingdom Arbitration Act are more extensive than that provided for under the Malaysian Act and include the ability to remit an award, to set it aside, to confirm the award or to vary it. It is very interesting to note, however, that in the United Kingdom, the setting aside of an award should only be employed as a last resort. This is in line with the view that the court's ability to set aside an award should be removed to enhance the efficiency of arbitration. However, as discussed by the American Society of International Law in their journal, there is no guarantee for due process and justice during arbitration. Therefore, parties need a method of being able to set aside an award, and this is provided for in both acts.
I will now conclude our presentation. It is clear that the UK Arbitration Act contains more provisions to facilitate the challenge of awards and appeals as compared to the Malaysian Arbitration Act. The time limits between the Malaysia and UK is different as shown under Section 37, Subsection 4 of the Malaysian Arbitration Act 2005 and Section 70, Subsection 3 of the UK Arbitration Act 1996. In Malaysia, an application for setting aside may not be made after the expiry of 90 days from the date on which the party making the application had received the award, and in the UK, any application must be brought within 28 days of the date of the award. This shows that Malaysia provides a longer expiry period in comparison with the UK. Moreover, appeal of an award is no longer allowed in Malaysia after the repeal of Section 42. However, Section 69 of the UK Arbitration Act operates extremely restrictively, as evident by the English Commercial Court Report of 2008, indicating that permission has been granted in 30 cases over the last 4 years, but only 5 of those appeals were successful. The various cases in Malaysia and the UK illustrated that the courts are reluctant to interfere with the decisions of the arbitration by only allowing an application to challenge an award and appeal in very, very limited circumstances. Thank you.